When Trump attacked Crockett's legal background, he had no idea she was about to school him on constitutional law in front of America's top legal minds. The House Judiciary Committee hearing room was packed with constitutional scholars, legal experts, and media representatives. The topic: federal court reform and constitutional interpretation. Former President Donald Trump sat at the witness table, flanked by his legal team, while Representative Jasmine Crockett occupied her position on the committee panel. The hearing had been proceeding routinely for the first hour when Chairman Jordan called for questions from committee members. Trump, accustomed to dominating any room he entered, had been growing visibly restless during the procedural discussions. His fingers drummed impatiently on the witness table as legal scholars presented academic arguments about judicial independence. When Crockett's turn came to question the witness, she leaned forward to her microphone with characteristic calm composure. Her legal pad was filled with carefully prepared notes, case citations, and constitutional references, the kind of meticulous preparation that had made her reputation in criminal defense. Mr. Trump, your recent statements suggest federal judges should be subject to political oversight. How do you reconcile this position with Article 3 of the Constitution? Trump's response was immediate and dismissive. Listen, I don't need lectures from someone who probably barely passed law school. You're what, a first-term congresswoman from Texas? I've been dealing with constitutional issues longer than you've been in politics. The room fell silent. Several committee members shifted uncomfortably in their chairs. Constitutional law professor Jonathan Turley, sitting in the gallery, raised his eyebrows at the personal attack. Crockett's expression didn't change, but her eyes sharpened with laser focus. I appreciate your assessment of my qualifications, she replied with devastating calm. For the record, I graduated magna cum laude from Thurgood Marshall School of Law and practiced criminal defense for over a decade before coming to Congress. I've argued constitutional questions in state and federal courts, including Fourth Amendment violations, due process challenges, and equal protection cases. But let's focus on the constitutional questions at hand. Trump waved dismissively, his gold cufflinks catching the committee room lights. Criminal defense? That's ambulance chasing compared to what I've dealt with. I've had cases in federal court, state court, bankruptcy court. I know more about the judicial system than most lawyers. Crockett nodded thoughtfully, then opened the thick legal folder in front of her. The folder was organized with colored tabs: constitutional cases in blue, federal court decisions in red, Supreme Court precedents in green. Her preparation was evident to everyone watching. Since you mention your extensive legal experience, let's examine your understanding of judicial independence. In your view, does the Constitution grant Congress authority to override federal court decisions through legislation? Of course it does, Trump replied confidently, leaning back in his chair. Congress makes the laws. If judges get out of line, Congress can fix it. That's basic civics. The constitutional law professors in the gallery exchanged knowing glances. Several began taking notes frantically, recognizing a fundamental misunderstanding of constitutional principles. Interesting perspective, Crockett said, her voice maintaining perfect professional composure. She pulled out a Supreme Court case citation. Are you familiar with Marbury v. Madison, decided in 1803? Trump hesitated for just a moment, glancing toward his legal advisors. Yeah, sure. Classic case. Everyone knows that one. Excellent. Then you'll recall Chief Justice Marshall's holding that it is emphatically the province and duty of the judicial department to say what the law is. Would you agree that this establishes the principle of judicial review as a fundamental separation of powers doctrine? Look, I'm not here for a law school exam, Trump said, irritation creeping into his voice. His face was beginning to show the first signs of redness. We're talking about practical governance here, not ancient history. Crockett's response was swift and surgical. Mr. Trump, you just told this committee that Congress can override federal court decisions through legislation. Marbury v. Madison established that the Constitution is the supreme law of the land, and courts have the final say on constitutional interpretation. Your position directly contradicts 220 years of established constitutional law. She pulled out another document from her meticulously organized folder. Furthermore, in Cooper v. Aaron, decided in 1958, the Supreme Court explicitly stated that Marbury v. Madison declared the basic principle that the federal judiciary is supreme in the exposition of the law of the Constitution. Are you suggesting the Supreme Court was wrong for over 2 centuries? Trump's face began to redden noticeably. That's your interpretation. Smart lawyers can interpret these things different ways. I've had the best lawyers, and they tell me Congress has power. Actually, it's not interpretation, Crockett continued, consulting her notes with professorial authority. It's black-letter law confirmed by the Supreme Court in dozens of subsequent cases. The room was completely quiet except for the scratching of pens as journalists captured every word. Trump looked toward his legal advisors, but they could only offer helpless expressions. One whispered something in his ear, but Trump waved him away impatiently. Furthermore, Crockett pressed on, opening another tab in her legal folder, you mentioned your experience with federal courts. In how many of your cases did you personally argue constitutional questions before federal appellate courts? Trump's response was defensive and evasive. My lawyers handled the technical stuff. I focused on the big picture strategy. That's what executives do, delegate to experts. I see. So you relied on your attorney's constitutional expertise while making strategic decisions. Crockett pulled out another document, clearly a comprehensive research report. According to public court records, your attorneys filed motions in at least 12 federal cases citing constitutional violations. In how many of those cases did federal judges rule in your favor on constitutional grounds? Trump's legal team was frantically whispering among themselves. The lead attorney was flipping through his notes, clearly unprepared for this level of detailed case law analysis. The silence stretched uncomfortably as Trump realized he had no specific knowledge of the legal arguments in his own cases. I'd have to review the records, he said finally, his voice lacking its earlier confidence. I've already done that, Crockett replied, holding up a thick stack of court documents. 0. In every case where your attorneys raised constitutional challenges, federal courts either dismissed the claims or ruled against you. She began reading from the documents. Eastern District of Pennsylvania, plaintiff's constitutional claims lack merit. District Court for the District of Columbia, executive privilege cannot overcome the demonstrated specific need for evidence. The constitutional scholars in the gallery were visibly impressed by Crockett's preparation and command of the legal details. Several were nodding in appreciation of her methodical approach. Trump attempted to regain control, his voice rising. Those were biased judges. Everyone knows the federal courts are rigged against me. Democrat judges, Obama judges, they had it out for me from day one. Mr. Trump, Crockett's voice carried a sharp edge of authority. You just accused the entire federal judiciary of bias based on unfavorable legal rulings. Are you familiar with the Due Process Clause of the 14th Amendment and its requirements for impartial tribunals? Trump looked increasingly uncomfortable, shifting in his seat. Due process means fairness. These judges weren't fair to me. They made up their minds before they heard the cases. Due process requires that defendants receive fair hearings before neutral decision-makers, Crockett explained with the patience of a law professor. However, unfavorable legal rulings don't constitute bias when they're based on established law and evidence. Your suggestion that federal judges rule based on personal animus rather than legal precedent undermines the entire constitutional framework. She paused, consulting her final set of notes, then delivered the knockout blow. Given your stated position that Congress should override judicial decisions, combined with your claims that federal courts are inherently biased, you're essentially arguing that our constitutional system of checks and balances should be dismantled whenever the outcomes are politically inconvenient. Is that your position? Trump's composure completely cracked. He stood up partially from his chair, pointing an accusatory finger. This is ridiculous. I'm not here to be lectured by some prosecutor who thinks she knows everything about law. Actually, Crockett replied with ice-cold precision, never raising her voice, I'm demonstrating exactly why constitutional expertise matters in governance. Your answers today reveal a fundamental misunderstanding of basic constitutional principles that have governed this nation for over 2 centuries. The legal experts in the gallery were taking extensive notes. Several constitutional law professors were shaking their heads in amazement at the systematic destruction of Trump's credibility. Chairman Jordan attempted to intervene, sensing the complete collapse of Trump's position. The gentlewoman's time is about to expire. One final question, Crockett interrupted smoothly. Mr. Trump, you've spent considerable time today questioning my qualifications while demonstrating unfamiliarity with basic constitutional law principles that first-year law students master. Would you agree that effective governance requires understanding the legal framework within which our government operates? Trump stood up abruptly, his chair scraping loudly against the floor. His face was flushed with anger and embarrassment, his usual confident demeanor completely shattered. This is a witch hunt. I don't have to sit here and be insulted by someone who's trying to show off for the cameras. Sir, Crockett said calmly as Trump gathered his papers with shaking hands. Constitutional law isn't showing off. It's the foundation of American democracy. Without another word, Trump stormed toward the exit, his legal team scrambling to follow. The cameras captured his humiliating retreat as he pushed through the hearing room doors. Crockett remained seated, calmly closing her legal folders as the room erupted in whispers and commentary. Chairman Jordan called for a recess, but the damage was complete. Within minutes, #Crockett Schools. Trump was trending worldwide. Legal scholars and constitutional experts flooded social media with praise for Crockett's methodical dismantling of Trump's legal arguments. The confrontation became an instant classic in congressional hearing history, demonstrating the difference between legal expertise and political bluster. Crockett had proven that preparation, knowledge, and composure could completely neutralize even the most aggressive political tactics. Trump issued no statements about the hearing and canceled his next 3 scheduled public appearances. The incident reinforced the importance of constitutional expertise in governance and established Crockett as one of the most formidable legal minds in Congress.